Well, hello, my friends. Welcome to me, your host, Christian Watson. My friends, the United States Supreme Court recently struck down a 108-year-old New York law which restricted a citizen's ability to carry a concealed weapon in public. Indeed, this law gave great latitude to bureaucrats who process concealed carry permits to allow them to deny a citizen's right to carry a gun in public if they fail to demonstrate a quote-unquote special need. So essentially, if you were in New York State and you wanted to carry a concealed gun in public, you would have to demonstrate a need beyond merely wanting to defend yourself. If your need or your justification for wanting to carry a gun in public wasn't what you wanted to defend yourself or you wanted to defend your property, that would not have been called a special need. Ergo, a lot of citizens in public in New York were not able to legally carry their firearms. Now, my friends, before I get into the topic of this video, which will be the distortion of language, words, and terms and values that leftists have had in reaction to this ruling, something needs to be stated. An ethical maxim needs to be stated here, now, and hence forever once it comes out of my mouth. It needs to be stated. It's been stated a few other times. Let me just restate it again because it's important. The Constitution guarantees an inalienable right to self-defense. And man having an inalienable right to self-defense and an inalienable right to be self-owning and thus have private property is someone who therefore has an inalienable right to defend himself with arms. The right to bear arms is a right the Constitution prescribes based on natural law. Thus, man is not needed, or rather, man does not need to ask permission to exercise what he already has in his possession. For the natural law theorist, this right of self-preservation was the right from which all others flow. Because if you're not able to live, you're not able to do anything else in life. You're not able to exercise your other rights. You're not able to be a good person. You're not able to contribute to the polity. You're not able to do anything else. You're not able to engage in debates on the Second Amendment. So it is obvious that the right to self-preservation is essential, and the right to bear arms is inherently, intimately linked with that right. And if I don't need permission to defend myself, because I don't, I also don't need permission, your permission, to go ahead and do it in public. That is the core of the problem here. It is an ethical certainty that we have these rights. And yet, many of the people who have responded to this ruling, many of the politicians and the literati, many of them have used consequentialist arguments, yes, consequentialist arguments, to justify the continued butcher of the Second Amendment and the assault on the inalienable right of self-preservation in the modern era. Governor Kathy Hochul said that this is just the beginning. She said she's going to use her perch and the executive mansion of New York State to continue fighting for restrictions on the inalienable right of self-defense. You had Senator Cory Booker echoing similar concerns. Mayor Eric Adams of New York City, a city that, amongst many other cities, is currently experiencing some serious crime issues, who said that this is going to make New York City become like the Wild West, the ability of citizens to defend themselves in public. The mayor of Buffalo said that this is also a concerning development. A mayor who probably would have been benefited from more citizens carrying guns in public. I'm certain the people in the supermarket who, God rest their soul, lost their life, would have been benefited to have more people there, not just one security guard. I mean, there's so many different kinds of people. President Joe Biden saying that it was just disappointing. Kamala Harris raising the alarm. Using these consequentialist arguments that this is going to cause more danger for more people. Well, my friends, the problem with consequentialist arguments is that they're based on faulty ground. They assume the goodness or the badness of a particular action based on whatever result they think it produces. Whereas the limitations of this is that, what if the result that thing produces only happens in one context? What if I can show you 10 other contexts where different results are produced? Or rather, what if I can show you 10 different contexts where 10 different results are produced? How in the world can we establish firm rules on the basis of a target that is already changing? This is the problem with the consequentialist ethic. But by the way, the right rightness or wrongness of an idea is not based on what it produces per se, as it is on its inherent right and wrongness. And the inherent ability for me to be able to preserve my life is a prerequisite for all else, and being that, it is inherently good. End of story. The Constitution recognizes that. It recognizes that against a backdrop of potential tyranny that comes from within the state that needs to be corrected sometimes by the people and deterred by the use of arms. That's the secondary consideration of the Second Amendment. But also, my friends, on Twitter, the term well-regulated trended for quite a while. And so many leftists were saying it says a well-regulated militia needs to defend the country. That means that's a stand-in for gun control. This is not the case at all. And so I recently did a Twitter thread, which you all can look at, and it'll be in the description down below, and it's up on air on the screen, explaining why the term well-regulated has absolutely no relationship with actual gun control, as leftists say that it does. And that their use of well-regulated in that context is actually an example of what we would call, as I've called in this channel several times, proximity ethics. So I'll give you guys a very short historical overview. There are two sections of the Second Amendment. There is a well-regulated militia being necessary for the security of a free state. That's one part. The right of the people to keep and bear arms shall not be infringed. That's the entire amendment. That's the second part. So, well-regulated militia, and then the right of the people to keep and bear arms, these are the two central parts of the Second Amendment. And so both of these two parts have two different origin points, and to understand the language of well-regulated and the language of to keep and bear arms, we have to understand the origin points of those two parts. So well-regulated militia, that part of the Second Amendment came from the sensibilities of people in Virginia, at least during the Continental Congress. So during the Continental Congress, a series of states came together, of course, to debate and discuss matters pertaining to the birth of the new nation of America. And one of those states, Virginia, happened to be a state that was influenced by what we call classical republicanism. Now, for those of you who are not familiar, republicanism is this method of government that is built around checks and balances, built with certain structures of representative capability that essentially secures political rights in some way, shape, or form through its various mechanisms. So, for example, a historical example to this, the Roman Republic, being a republic, was one built upon a constitution, or rather, that constitution of the Roman Republic was actually pretty loose, and there were more so general principles and guidelines instead of being binding rules like our constitution is supposed to be. But still, in the Roman Republic, a few key features was representation. It was the political rights of certain people, or being secured and things of that sort. And this is what is endemic to a republic, preserving the free state. Now, a very key part of preserving a free state in classical Republican thought is indeed the existence of militia. And so George Mason and other people of the Virginia delegation, they had this idea that the militia, which existed essentially in direct relation to property ownership, was necessary for what would be called the free state. Now, you had on the other side here the Pennsylvanians, or the Jeffersonians, as David Hardy explains in his essay, in his great essay that I'll link down in below for you guys, who had a different view. They didn't believe that rights were inherently tied solely to your ability to own private property, or solely rather to your property possession, but rather rights were contained within the DNA of your humanity. They were as intrinsic to you, or are as intrinsic to you as the ability for you to breathe is. Ergo, the right to defend yourself, which is also intrinsic to you, and not based on property ownership, but rather based on self-ownership, natural self-ownership, the right to defend yourself was one of those rights, and the right to bear arms is an exact consequence, an exact extension of that right. Now, these were these two visions, and for a long while, up until 1783, these two visions were distinct. But then George Mason and others changed their mind, And people who endorsed classical Republican thought changed their mind when they began seeing the abuses of Great Britain during the Revolutionary War, and they decided, no, the right to defend yourself is not merely a nicety for some people who can own property, but rather it is essential for any human being who wishes to sustain their life in the first place. If the individual can't sustain his life, the polity doesn't exist, the republic can't even exist. So the right to self-defense, my friends, is an antecedent to the republic. The problem is the classical Republican thought focused entirely on structure and the items of that structure, but not enough on bases. If a house is defined solely by what it looks like and not its foundation, then guess what? The foundation being unknown and being weak can collapse like that, and the structure of the house tumbles and dissolves under that weight. So the Jeffersonian position understood both bases and structures, but the Masonian position and the Virginia position, they only understood structures, but the two came together in the precursor to the Bill of Rights when they were debating the need for the Bill of Rights, and James Madison, the father of the Bill of Rights, tied both perspectives together and put both perspectives into the Second Amendment, hence a well-regulated militia being necessary for the security of a free state. The right of the people to keep and bear arms shall not be infringed. The first part of that statement is a political statement meant to appease people who were still bound, or still sympathetic, but not necessarily bound anymore to the problem of structure. Whereas the second part is an affirmation of the universal right of everybody, regardless of their condition, regardless of their status, everybody, by virtue of their humanity, to defend their life, to preserve themselves, the most basic and fundamental of our natural rights. So my friends, next time you hear someone say, well, regulated means gun control, or they try to use sophistry and obfuscation and perhaps your relative unawareness of historical knowledge to dupe you, just remember that it requires no historical knowledge to understand that you as a human being, in your capacity right now, are endowed with certain faculties and qualities that without which you cannot live. And you being able to live and exist in this world is the basis for everything else. I'm sorry. Without your life, without your vessel for what you go through this world, everything else is inaccessible to you. That is why the right to self-defense is almost even primordial, primal. It pre-exists society. It pre-exists political structures because it was man's only way of allowing himself to get to the point where he can enter into society, where he can enter into political structures, where he can enter into commerce with other souls. That's why it's so important. So well-regulated, my friends, never meant well-controlled. It simply meant, in its most basic form, a well-functioning militia, and the militia was added into the Second Amendment simply because the ideas of classical republicanism were influential in the milieu of the founding. But classical republicanism was amended by our brilliant founders to also include the basis of natural law and natural rights, the natural right of self-defense. When base and structure are combined, you have a building that is unassailable, that is beautiful, and that is very sturdy. The founders skipped the mistakes of their predecessors in Rome and elsewhere and combined the base structure combination of good structure and good moral theory and created the beautiful nation we have today. And leftist politicians want to actively undermine that, and we cannot let them. These inalienable rights are not negotiable, and no amount of dead-end thinking from leftist politicians or leftist activists can change that. No amount of consequentialist thinking can change that. And if we stand on these axioms, they will not be able to even come close to changing that. Think on it, my friends. I love you guys so much. If you love me, please be sure to go to my Patreon, patreon.com/officialcwatson, or my PayPal, which is going to be officialcwatch@gmail.com. Be sure to like this video, subscribe to this channel, share this video, comment on this video. My friends, this message is dynamite. I love you guys so much, and please stay pensive. Bye, guys.